dominated by the weak domestic companies. But and over time, the level of protection has been reduced significantly. And I have to say that we often talk about the concept of effective rate of protection, which is the level of increase in value added under the trade policy instrument compared to the case of without the trade policy instruments. So the level of protection in Vietnam has been decreasing rapidly. There has been some technical reasons for that, but one critical technical issue is that Vietnam did not have the capacity for policy making and for policy analysis that could have tied the two sectors, the export-oriented sectors and the import substitution sectors. And still in this process, we emphasize the need to promote industrializations. We want to modernize the economy, but we talk a lot about these issues, but going into details and making use of the trade policy instrument to attain that, we do not have enough capacity. And so, so as mentioned previously, we have the trading rights gradually introduced and expanded for own enterprise since 1998. And then on the other hand, the direct subsidies to the SOE were reduced as part of Vietnam's effort to enforce the hard budget constraint on these enterprises. So we want to the SOE to acknowledge the fact that their budget will not be the same as the state budget. They have to work on their own. But the hard budget disciplines are on them, so they have to make the decision to focusing on their revenues, on their costs, and then at the end of the day, any loss by them will not be covered from the state budget. And so we want them to work on a more commercial footing. But since 2005, the talks about subsidies in Vietnam start to focus more on the agricultural sectors. And so I think perhaps it was because of the WTO accession that that people have a stronger, a greater interest on the possibility of making of using subsidies, and they start to recognize that subsidies can be more probable under the WTO framework for agriculture, but for manufacturing there will be less chance for using them. And again, the price liberalization also reduced the implicit subsidies provided for the manufacturing firms. So if we increase the electricity tariff to a market level, then that will reduce the incentives for the electricity intensive sectors such as the steel. But if we want to, we still emphasize in the old time, we emphasize the fact that steel production and steel exports are very important. So we want to get some support from the domestic SOE companies, and so the electricity tariff had to be set at an artificially low level, and that would help the steel sector, but that would imply a cost for the SOE in electricity, and that also impose a cost to the budget of the government. So in terms of so one question you may say regarding why we talk about the non-tariff barriers here, because it tends to deal more with the import from the other countries. I have to say that this is on the two-sided coin related to the subsidy issues. So on the one hand, you have to deal with the subsidies under the WTO framework. You have to deal with the subsidies that you could provide to your exporting companies. And then on the other hand, you also have to deal with the impacts of the subsidies by another partner WTO members when they export to your country. So for example, if this member A, they want to export to Vietnam and they are using some subsidy in the process. what would be your available measures to do with that? So maybe you can revert to the countervailing measures, which are permitted under WTO framework, but you can choose to, if they're big enough, if they're economically significant enough, you can also revert to retaliatory measures. So you can also impose something like a non-tariff measures on those products. And that's, but in the case of Vietnam, in the late 1980s and early 1990s, we also start to impose to introduce some non-tariff measures. But these non-tariff measures were very simple. For example, the trading rights I mentioned previously was one type of the non-tariff barriers. The other issue, the other type of non-tariff measures was the quota. So we imposed the quota on a number of products, including export of textile garment in the old time, the textile garment on quota on some important product like the poultry eggs. But since 1994, when we start the industrialization program, the quantitative controls on some key imported goods, like including the processed agriculture products, have been and sold and things like that have been introduced. And the thing is, they have the main purpose to protect some domestic industries under the import substitution strategy. But during the 1999 to 2004, Vietnam started to replace the non-tariff barriers with the tariff. And in that process, we call the process as the tariffication process. So meaning that we are replacing the non-tariff barriers with the tariff. There was some reason for this process. First, people said that the non-tariff barriers were quite non-transparent and they were quite distorting. They were hard to document the impact, because for the tariff, the calculating the impact would be more straightforward. But another reason could be that at that time Vietnam already started to prepare for the WTO accessions, and people said that by replacing the NTB with the tariff, so actually Vietnam could increase the set of the most favored nation tariff rate, and on that basis of the high tariff rate, Vietnam could then negotiate for the accession bound tariff level after the WTO accession. So you could see from the graph here, when we start to the tariffication process, the average most favored nation tariff also increased. But like I said before, this kind of thing also reflects the fact that Vietnam did not pay much attention to the sophisticated non-tariff barriers, including the concept of non-tariff measures. I think you, at this stage, you are probably aware of the difference between the non-tariff barriers and non-tariff measures. But in the old time, Vietnam did not have that kind of clear distinction on that. And not to mention, I mean, whether we'll be willing to, even if we know the difference between the non-tariff barriers and the non-tariff measures, will not be willing to proceed with imposing the non-tariff measures that are not the non-tariff barriers. So before the WTO accession, in order to promote export, Vietnam has implemented various measures to including the zero export duties. So we say you don't have to pay for export tax. We also have the duty drawback scheme. So it means that if you import the input for export-oriented production, you will be eligible for the repayment of the import tax after you clear the export orders. There may be some sort of like export support credits and rewards. And in this process, the Export Promotion Fund was established to assist and to encourage and to promote export. So there's a fund from the government before the WTO accession. But after WTO accession, we have to abolish this fund. And there were also subsidies in the forms of interest rate support, direct financial support to first-time exporters, and for the export to new market, and for the goods that are subject to major price volatility. So, for example, if you are making exporting to some market that you never export before, you might be eligible for some financial support. But in fact, before the WTO accession, there was no anti-subsidy investigation case against Vietnam. And in this process, Vietnam also recognized the possible subsidies by other countries upon exporting to Vietnam. But we did not take the countervailing measures, not just before the WTO accessions, but even between 2007 and 2010. After 3 years after WTO accession, we did not take any actions, including the countervailing measures against the case where we deemed that the member were using subsidies in exporting to our country. So in this process, there was some, I have to say that the issues, the awareness related to financial support to export has been changing rapidly before Vietnam's accession to the WTO. And one reason for this was the repetitive training programs for a number of exporters related to the issues of eligible subsidies under the WTO framework for manufacturing products. And I have to say that and at that time I attended some training, and some of the people, some of the exporters from government companies even asked some questions like this at that time. They said, I understand that when Vietnam became member of the WTO, Vietnam would not have the export bonus, including the export bonus for the government exporters. And I think that is acceptable. And for the sake of Vietnam as a whole, we understand that the abolition was necessary. But would it be possible for the government to provide some small, very small monetary support for the exporter as a reward? So of course the reward would not be sufficient to change the export decisions. But if we have some reward, then that would be good. But then we keep the speakers at that time had to keep repeating that any kind of financial support to the exporter, even in the form of export bonus, would not be eligible. And so after some time, people start to recognize that, and no, that kind of question was not mentioned again. So the next bit is Vietnam's negotiation for subsidies and countervailing measures under the WTO accession. And so in this process, we had previously I mentioned that Vietnam started to intensify the negotiations for WTO accession from 2002 to until 2006. And so at the time, we also had to notify the subsidies for the period of 2001-2002. And in that process, we also had to notify the criteria for granting the subsidies, and we had to prepare for the working party before its 7th meeting in May 2003. So in May 2003, they said there are still, which is one of the first rigorous working party meeting, members still express the concerns and they want more information as an elaborations about the subsidies in Vietnam, about the broader economic regimes in Vietnam. So what is the role of this, like I said, what is the role of the state sector? What are the subsidies available for industry, for manufacturing? What are the subsidies for the state-owned enterprise in manufacturing subsectors and things like that? So people, so these kind of questions are direct, and they are not just about the subsidies in manufacturing in general as part of the SCM agreement. Instead, it can also be linked to the other issues like state-owned enterprise, for example, agriculture products. Certainly, we have the agreement on agriculture, but still, I mean, it's said that this kind of thing can be linked to the other issues. So it's not just about the scope of the subsidies alone. And the additional question and replies sent in by members to Vietnam in November 2003, there was also some question about the export bonus in Vietnam. And so you could see that people ask questions very directly to the type of question and the type of issues that Vietnam had. And Vietnam has to justify that we will be committed to removing the export bonus. And I think more informally, export bonus were often mentioned often granted to the export of textile and garment, for example. And so when we make the justification under WTO framework, we had to talk about justify the need, the commitment to remove the export bonus, but also in terms of the bilateral channel when we discuss with partners. We also said that for textile and garment, I mean, we understood that the quota regime will also be removed under the WTO by 2005. So we will benefit a lot from that, and so we would not need the subsidies for the textile and garment companies once we get access to the WTO regime. So it also means that there could be some sort of like different justifications from the applicant's perspective. You don't have to talk directly that we are just committed to implementing the commitment under the SCM agreement. Instead, you could say that actually you have the incentives to do so. Of course, I think the case for the textile and garment are different these days, but it just means that in manufacturing sector, you could have a number of issues related to that. And certainly at this stage, when everyone's talking about green transition, about climate change, about sustainable development, the support to promote sustainable development can be also some sort of like justifications that you can revert to. In December 2004, at the Working Party, one member also mentioned that Vietnam Vietnam requests to be granted a transition period in order to implement the SCM agreement. And this member stated that Vietnam would not automatically get the transition. We had to justify that. And so they encourage Vietnam to use the subsidy not prohibited under the WTO agreements. And other members said that they also want Vietnam to implement the agreement directly upon its accession, immediately upon its accession. But alternatively, one developing country member argued against the case. They said that Vietnam should be entitled to special and differential treatment on subsidies. So of course, like in the previous examples about SOE, this kind of focus support can be less probable, just because not everyone, not all WTO members have a big SOE sector. But in terms of subsidies, a number of developing countries are reverting to that, and not just about the agriculture sector, where the consensus on subsidies is larger. But even in manufacturing, some people are still talking that Vietnam should be entitled to the SDT on subsidies. So it means that if some existing WTO members can lend the support to you by saying that you can be eligible for the SDT on subsidies, and so other members should take a positive view of that. So the implication is you also need to talk to some potential WTO members in your partnership, and so that they can be willing to voice out the support to you on this matter. And the next thing is in terms of the next meeting in September 2005, they mentioned explicitly that subsidies are among the issues that concerned by members when they consider the issue of Vietnam's SCM. And in March 2006, Vietnam submitted the new and updated notifications on the industrial subsidies for the period 2003-2004. And members of the Working Party still had questions on the draft law awaiting approval on the subsidy itself, so including the enterprise law, the investment law, and they said that what if we have to decrease on that, and what kind of subsidies that can be provided to them. And in fact, they are not talking about the direct subsidies to the enterprise, to the manufacturing enterprises. Instead, they talk about whether Vietnam would have the to provide some investment incentives for a number of sectors like the export processing zones. So we have to keep on justifying that we will maintain the export processing zones, but all the firms going into export processing zone will be eligible for the investment incentives. So meaning if the firms make investment in the export processing zones, and even if they are not making they are not having any direct export, they will still be eligible for the investment incentives. So it means that the investment incentives work on universal basis, and it is based on the geographical areas, and it's not meant to provide some sort like discrimination against the other exporters in the same industries. And in the process, Vietnam received a number of questions and regarding export subsidies and regulatory changes and potential compliance with the WTO agreement on SCM. So like I said, they said that another example is that there are a question saying that the members acknowledge Vietnam's response to concerning the access to flexibility under the Article 27 STM agreement, i.e. the SDT. And Vietnam said that it is entitled to maintain export contingent incentives. And so we wish to reiterate that Vietnam is not one of the developing countries that are automatically covered by the flexibility under SDT, and any access to the flexibility must be negotiated with members of the Working Party. And we would have difficulties accepting subsidies that Vietnam has already eliminated in practice, such as incentives for import substitution project. So if it means that if Vietnam has already eliminated the incentives for import substitution project already, Vietnam cannot revert it back using the flexibility under the SDT provisions of the SCM agreement. And so the justification from Vietnam was that we took note of the comments, and we said that the export contingent incentives are mainly for encouraging investment and economic development. And so we are not going to say that we are aiming to target export promotion. So, and we hope that members of the Working Party will show flexibility in considering these issues. And another question similarly, they said that could Vietnam clarify in the draft Working Party report text about its proposals for the removal of the discriminatory taxes on automobiles. And they said that this is this is the thing that they tend to talk about when in the old time, just before Vietnam's accession, because the government has a long-term target to promote the production of the automobile in the country. And so we did it to promote the industry. We use a number of policy incentives, and including the granting of the excise tax deduction for the automobile producers in their early development stage. So from the early time, for some time, this kind of automobile producer would be eligible for some deduction of the excise tax. But during the WTO accession negotiation, we have to justify that this policy aimed to support the infant industry enterprise at the early developing stage. And when we issue the investment license, we have to make the commitment already with the enterprise on the tax treatment, including the excise tax. And so And so we noticed that the subsidy to the automotive industry through the excise tax deduction will be subject to the SCM agreement, and therefore Vietnam will make the commitment to gradually eliminating the incentive of excise tax deduction. So we say that we will not eliminate the incentive immediately upon the WTO accession. We had some reasoning so that we say we need some transition period in order to implement this. And indeed, after the WTO accession, Vietnam started to revise the law on excise tax, and it took us about 2 years before we could complete this law. And so and that was also consistent with the WTO commitment on that. So it also means that even if you have to phase out the subsidies, you can still have a strategy for seeking a transition period rather than attempting to phase in the commitment immediately. Of course, member want you to do it immediately, but there could be some reasoning from your capacity to do to seek flexibility. And again, like the next question deals with the export processing zones and whether the firms in the export processing zone can receive the incentives, especially when it is referred to the export capacity, and the firms and the export processing zones are very much likely the firms who are directly involved in export activities. And so then the question mentioned that Vietnam revised the law on investment as an attempt to prepare for the WTO accession in 2005, but because of the classifications in the investment law, they said that all the incentives listed under the investment incentives are also granted for the export activities. And so this may be the prohibited export subsidies under the SCM agreement. And so how would you explain that? And so in the case of Vietnam, we mentioned the articles 32 and 37 saying about the investment incentives for investment in exporting zone. So in this process, we are referring to investment incentive and investment activities. We are not referring directly to the export activities. Of course, the exporters in the making investment in the export processing zones can benefit from that, but that kind of benefits are not automatic because they still need to be subject to a number of conditions, whether they are eligible to make investment in the export processing zones. And even if you are eligible for that, you still have a number of processes, including the production decisions, in order to get the export orders in good shape. And so we mentioned that in implementing decrees of the law, these incentives shall conform to Vietnam's commitments on subsidies. So the incentives will not be contingent upon the export performance or the local content. We don't have that kind of requirement anymore. So the firms in the export processing zones are not required to export their products. And in any case, they are entitled to receive incentive in the forms of facilitations of investment procedures, rent of land and premises, support in the supply and training of labor, water, power, and other public utilities within the export processing zone. This kind of thing can reduce the cost for the firms, but they are not direct financial support. So the next bit is the ordinance on the anti-subsidies of products exported to Vietnam. So like I said before, the previous section deals with how Vietnam negotiate the commitments for refraining from using subsidies in export to the WTO members. The next, but that is not just about, that's not all about the SCM agreement. In order to implement the SCM, you also need some capacity to deal with partners in the case they provide support to their export to your country. So it's not just about refraining from using export, refraining from using incentives or support when you export, but you also need some capacity to deal with the imports that may be subject to the use of subsidies when entering your country. And with that perspective, Vietnam also issued an ordinance on the anti-subsidies of the product exported to Vietnam. And this ordinance was issued in 2004. At the same time, we talk about the preparation for enterprise law, investment law, and also the law on and a number of ordinance on the imports of agricultural products and things like that. And the ordinance entered into force on the first day of 2005, and it was repealed at the end of 2018. And actually, it was repealed not because it was no longer necessary. Instead, in 2017, we issued the law on foreign trade, and this law became more comprehensive, covering a number of issues related to trade remedies and things like that. And that's why we include the issues on anti-subsidies of products exported to Vietnam under that law. And so this ordinance became nullified. And this ordinance, when it was issued, it prescribed the measures against the subsidies by partners when they export to Vietnam, about the procedures and contents of investigation for applications, and the application of such measure to the subsidized imports to Vietnam. So this is the legal framework. So if the firms in Vietnam, they believe that the imported products benefited from the subsidies by partners, by originating countries, and they are having some sort of adverse impact on the livelihood of the domestic industry, they are hurting the local employment, they have some ground for making submission to the authorities in Vietnam and to ask for some investigations on these issues. And on this kind of application, an application for investigation was accepted, the authority would take actions, and then they would have some sort of like quick period to have some sort of temporary measures, temporary countervailing measures. And so, and during these kind of temporary measures, the importing countries and their companies will still have to make further justifications. They can, and they will have to protect them, have some ground to protect themselves on that. And if they can give a satisfactory justification, then the decision can be changed into a more permanent one, with like implications like usually for 5 years. So in this article, we said about the forms of the subsidies. And here we mentioned that the government or government agency transfer the capital to organizations or individuals in the forms of capital allocation, share transfer, soft loans, or guarantee for loans at an interest rate lower than that applied to loans without guarantees. So if members are used, if the governments in partner countries are using guarantee for firms borrowings, so that they can benefit from lower interest, that is also a form of subsidies. And the second case is that the government or government agencies leave out or don't collect the revenues obligatorily payable by organizations or individuals. So meaning that if the exporters, they are liable to some taxes, but if the government are not collecting those taxes, then they benefit from the subsidies. There are also cases when the government and government agencies supply the goods and service at high price and resell them to the organizations or individual at price lower than the market price. And they also contribute money to financial assistance mechanisms and for example, some export promotion fund and things like that, and other subsidies other than those defined in the previous clause. And then on that, if there is a ground for there is a case for the subsidy, then we may consider using anti-subsidy measures. And the first most direct measure is the imposition of the anti-subsidy tax. So if you are benefiting from subsidy there, we impose a tax over here, and the extent of the tax will depend upon our justification, on your justifications about our assessment of the impact or the damage that your subsidies are creating to our domestic industries. And of course, there's also a less stringent measures by that in the second clause, where we accept the commitments made by organizations, individuals, or government of the originating countries regarding the voluntary termination of the subsidies, the reduction in subsidies, the adjustment of the export price or applications are the suitable measures. So if we have maintained a communication channel with the partner countries, we could be just satisfied by the fact that they are making commitment not to repeating these things. They are making commitments to reduce the to revert the damage caused to our domestic industries and things like that. And the conditions for the applications of anti-subsidy measures, we say that the anti-subsidy measures will apply to subsidize imports into Vietnam only when the imports are determined as having subsidized, and the imports cause threaten to cause material injuries to the domestic production entities or premises or branches in Vietnam. And the ordinance also says about provide other details related to the grounds for the investigations, what are the informations and documents that need to be provided in the investigation process. There are also some provisions about how we determine the subsidies and the material injuries or threat to cause material injuries to domestic productions, and also about the imposition of provisional anti-subsidy tax and anti-subsidy tax, etc. So having this kind of thing is very important because, like I said, if you want to make use of the SCM, you also when dealing with subsidized import from partners, then you cannot always revert to the WTO framework. Instead, you need your own domestic legal framework that can deal with this issue. So they can say, so then that is the thing that we will need to consider when preparing a legal framework to deal with the product that are exported to your country. Without that kind of legal framework, you will have a number of challenges. Even if you believe that there are some ground for the violating the SCM agreement, you don't have some legal framework to start with from at the domestic level. And so reverting the WTO accession can be lengthy, can be more costly, and may not be helpful to the realization of your purpose. So we have that framework. So what is the actual implementation of anti-subsidies in Vietnam? And on both sides, whether we implement the anti-subsidy process against the import from partners, or our partners using anti-subsidy investigations against Vietnam's export. So the statistic until mid of last year said that Vietnam only launched one subsidies investigation against sugar import from Thailand, with a final decision to impose an anti-subsidy tax of 4.65%. And I think as the sugar sector has been very important for Vietnam, but this is related to agriculture sector. So with the manufacturing sector, we don't have any anti-subsidy investigation on that. And in terms of the export to other countries, by June of last year, our export products have been subject to 23 anti-subsidies investigations, and the first case only began in 2009, 2 years after the WTO accession. But we did not have we were not subject to any decision to impose anti-dumping, anti-subsidies, or countervailing duty. So, but in this process, there is some debate in Vietnam. I believe the debate started from 7 years ago in 2015, and still continue until now. The debate is related to what should we do with the actionable subsidies. I think we believe that I think under the SCM there are two types of subsidies. The first one is the prohibited subsidies. So everyone agreed that we should refrain from using the prohibited subsidies, or we must not use the prohibited subsidies. Everyone agreed on that. But what about the actionable subsidies? The subsidies here, these kind of subsidy here can cause serious prejudice in the case of by impeding or displacing other countries' export into the market of the subsidizing country, to third countries, or those kind of subsidies may significantly undercut the price of a like product. It may increase the world market share of the subsidizing country and things like that. So what should we do with the actionable subsidies? One line argument is that we should actively make use of the actionable subsidies. When people take actions or challenge our use of the actionable subsidies, we continue we enter the litigation process, we enter the dispute settlement process, and any kind of thing happen, we're happy to pursue the litigation process or dispute settlement process with them. But we are not afraid of using the actionable subsidies. So and the benefit is clear, because if you use the actionable subsidies, it's not always the case, at least theoretically, that the partners will take action against you, because this is a cost. This kind of decision also entail cost-benefit considerations. So if the cost of having a dispute settlement mechanism over something that are not prohibited subsidies is overwhelming to compare with the benefits from doing so, then the partner will not do that. So so we should not be afraid of using the actionable subsidies. That's one thing. And the second benefit is that even if you enter some dispute settlement mechanism on that, that kind of process may not lead to definite decision, and the decision may not be definite against your country. So just proceed with that, and when the case happens, we go along with it. But another live argument, which is more popular in Vietnam, I'm not sure if it is fortunate or unfortunate from the WTO perspective, but in Vietnam, people said we should not pursue the actionable subsidies either. The reason is we are very much afraid of dispute settlement. The word dispute is not a good word in Vietnam, and in our culture we tend to say that they are in dispute because they must have done something wrong. So and in Vietnam we have a saying that said, if there is no fire, there will be no smoke either. So if there is some smoke, it means that there must have been some fire. So it means that if you are if some partner country asks you to go to to go to a dispute settlement process, it is you that must have done something wrong. So from the reputation perspective, some of the government agencies in Vietnam will not be in favor of that. So they say, it's best that we avoid making use of the actionable subsidies. That's one thing. On the other hand, even if some of the agency may say, okay, we understand the argument for using actionable subsidies, but the thing is, we have only a small team of people, and we are short of resource. So if we have too many dispute settlement cases, we just don't have enough people to follow these cases, and that will hurt our operations. And so we should avoid using the actionable subsidies right from the first place. So that is the second argument. And the third thing is, unfortunately, some government agencies say this kind of thing may benefit the exporters or the private companies at the expense of our political career. So we may not risk that. So I think this kind of debate can be quite extensive, and each groups in Vietnam may have a different viewpoint, and they have a strong argument for their perspective. But I think in the case of Uzbekistan, when you're negotiating the SCM agreement for the WTO, you need to consider this thing. So I think in terms of the trade policy reviews, what have they said about our use of subsidies? The first trade policy review by the WTO Secretariat in 2013 said that they refer to the case in 2009 when Vietnam suffered from the adverse impact of the global financial crisis. So the government decided to use a fiscal stimulus package valued at $1 billion US, and that package involved 4% interest rate subsidies for business and individuals. And of course, then in the justification process, we said that the interest rate subsidy here are for the emergency cases for the general business community, and we are not targeting the support for the exporters during difficult times. And but still, I mean, the wording is we still have a reference to this case. Of course, they're not judging that Vietnam is providing subsidy related to exporters either. But this is just to say that anything related to support to the business, even in general, not just specifically for the exporter, can be referred to in the trade policy review process. And they also said that Vietnam did not provide the subsidy notifications until March 2013, when it notified the details of support programs applied in 2005 and then 2007. Without a more recent update, the information contained in this section can only be considered indicative of the kind of support provided to specific industries, or more generally available to encourage investment, regional development, research. Moreover, the Secretariat has no reliable data on debt forgiveness to loss-making state-owned enterprise and private enterprises. So again, as I mentioned, they also refer to the debt forgiveness, which can provide some sort of like subsidy in a sense to the SOEs in Vietnam. But this kind of thing can also be in some vague arguments too. They are not having a strong argument for the subsidies for the SOEs in Vietnam either. And for the second trade policy review by the Secretariat, they said that Vietnam did not submit the subsidy notifications to the WTO between September 2015 and February 2020, and when the notification does not contain data on the program subsidies per unit, the authority state that due to limited resource, they were not able to collect the data. But so I think but this kind of issue did not mean that Vietnam violated the commitment related to SCM. It just means that during the process there could be some gray areas related to subsidies that they may have some suspicion, or they may can have some argument or question regarding that, but they are not accusing Vietnam of making the violation. So what are the key lessons? I believe that the key lessons here are structured in the way that is consistent with the lessons in the previous case studies. But I'm elaborate here on in the sense that first, we still need a long-term credible plan or strategy for economic development and market-based institution with the minimal trade distorting instruments. So we are not going to say that we will rely on subsidies in the long term. Of course, there could be some substances, but if those kind of subsidies are tied with the general business community, they are tied with the emergency cases such as the global financial crisis. Of course, we would not want to join the to have a global financial crisis. No one wanted that, but if it happens, then we need something to revert to, and we should not be afraid of making use of those kind of subsidy, because those kind of things help with your economy, because after all, you still have to live with your economy first. And so in the process, you may want to ensure that you're taking incremental step. You don't necessarily have to try to phase out everything at the same time. You may want to have a roadmap for that, and it's your responsibility, it's your capacity, and it's your trick in working with the WTO members to negotiate for some flexibility for you in the transition process. And the next bit is building the consensus about what should be expected. For example, if people give you the flexibility in making use of subsidies to manufacturing enterprises, would you have the capacity to do so? Would you have the budgetary resource to do so? I think that's not, in the case of Vietnam, we had serious budget difficulties after the global financial crisis. And so when we justify the fact that we just did not have enough time to not have enough resource to pursue larger subsidy scales. So we only have a package of 1 billion. And if you ask, even if you allow us to have a bigger fiscal stimulus, we would not have been able to do so. So it means that you should be, you also need to to develop some expectation. Well, if you can have subsidies, if you can't have the subsidies, what should be expected, and what are the trade-offs during negotiations? So, for example, in terms of subsidies for the state-owned enterprise, would you be willing to work on both SOE negotiation and SCM negotiation? What are the level of coordination required across the agencies? And to do that, you need to and if they have differential views, what would you do? And then you also need to build consensus on the complementary reforms on industrial and fiscal policy. For example, in terms of industrial policies, you need to consensus on the investment incentives for the firms in general, and perhaps you still refrain from using subsidies for exporters. But how would you communicate to the stakeholders to ensure that you're implementing the WTO commitment seriously? You're not trying to manipulate over the wording in order to provide some support to your industrial firms, because at the end of the day, your subsidies may not last forever. And on the other hand, even if you are able to manipulate to provide subsidies to the industrial firms, whether the industrial firms will not become over reliant on your subsidies, or they can grow up. It is another issue to consider. And then the next issue is the attitude to actionable subsidies. So if the negotiation team, if the government agencies reach a consensus on promoting the actionable subsidies, and when things and when people ask for dispute settlement process, we'll take the actions by then. But the people may say, even if you are agreeable to that, but from the people's perspective, they may not have enough information, and they may say, these guys are subject to dispute settlement by the partners, and they receive a number of complaints. So perhaps they haven't done a proper job in the negotiation process. So having this kind of thing does not mean that you should be afraid of the actionable subsidies, but instead it also means that you need a rigorous, transparent, and appropriate communication to the stakeholders, not just the government agency, but also the people and the business community on your concrete directions regarding the actionable subsidies. And then you also need to build consensus about if you can have some subsidies for some domestic products, then be some beneficiary. But the other countries may not take the actions directly to those products. Instead, they may retaliate by taking actions against other export products from your country. So it means that some exporters in your country benefit from the subsidy, but the other exporters may be hurt by the retaliatory measures from other partner countries. So how would you build the consensus on that, and whether to avoid the case where the firms being hurt may say, the government is supporting those companies, and we are having the side effect of those process. And the next bit is about the intensive training for negotiators. What can be the subsidies? What are the subsidies that are eligible? What are the subsidies that are actionable? So how would you translate those kind of things at the negotiation level into the domestic laws? And in this process, whether you need a public consultation is also another issue that you need. Because, for example, during the public consultation process, people, including the foreign firm, may have the chance to participate in your rulemaking process. They may be heard, they may hear about the information, about the documented evidence about the subsidies in your country, and so that may have some implications for the trade policy review process, and that may have some sort of like judgment against your country in the WTO process. And finally, again, we also need to work with the existing members. Not all the WTO members are your enemies. Indeed, they will benefit a lot from you, and they can be your supporter along the negotiation process. So try to work with them, and subsidies may be a sensitive word, but it is also the topic of a number of developing countries. So just try to seek the shared experience from the existing members, how they negotiate that, how they promise to fulfill the commitment after the accessions, and how they deal with the actionable subsidies, and how they communicate with the stakeholders. You have a lot to learn from them, and indeed, through the bilateral consultation, they may be able to help you. They may also voice out the concern. Like I said, in the case of Vietnam, some members also talk about the need to grant Vietnam with the SDT on subsidies issues. So, but again, subsidies are also tied with the issues of market economy and non-market economy, and lessons of China and Vietnam also show that negotiating over these issues are not simple. especially when you also have sectors related to state-owned enterprise. So because the subsidies are not for the exporter themselves, it can also be to the state-owned enterprise, whereby some of them may be the major exporter of some products. And so this kind of thing, you can't hide the information on this kind of thing. But even if you do things correctly, people may not recognize you as the non-market, as the full market economy under the WTO framework. So with that, you're still subject to countervailing duties about anti-dumping investigations and taxes. You can't do anything about that, but once you can't do anything about that, you can also leverage on the use of the rejection by partners against your market economy status to negotiate for further flexibility. So if you can't get the market economy status, perhaps you can also get a good size in terms of the flexibility on a number of issues, including the subsidies. And so with that, I would like to end my presentation on the second case studies. So if you have any questions or comments, please feel free to let me know at this stage. If you have, if you believe that you can only have questions after some thorough investigations of the case studies materials, just feel free to get through the people at the IEC, and they will channel your question to me. Thank you.